A motion to suppress could be for a lot of things, but generally speaking, it has to do with evidence that we don't think is sufficient to meet the bare minimum standards that the state is supposed to uphold. So for instance, we could have a motion to suppress for lack of probable cause. That's oftentimes one of the most common motions to suppress that the defense may file. So let's take a DWI case, for instance. The state has to prove that the officer pulled my client over for a lawful reason, meaning the officer had to have probable cause to pull my client over. If we believe that the evidence does not show the officer had a lawful reason to stop our car, or our client's car. So for instance, if we think the officer pulled our client over simply because our client was a minority, we often call this driving while black. If we think that the officer had no other reason to pull our client over other than the color of his skin or some other discriminatory purpose, then we'll file a motion to suppress the entirety of the state's evidence because the underlying reason that the officer stopped our client was an unlawful reason. So the process to file and argue a motion to suppress starts with the defense attorney thoroughly reviewing all of the evidence that they have available to them. Once the defense attorney has identified cause for filing the motion to suppress, so for instance, if we've reviewed the evidence and we have found that we don't believe the officer pulled our client over for a valid, lawful reason, then we will draft a motion and we will explain in a written format to the judge what our case is and why we think the state has failed to prove probable cause. And then there will be a hearing that's scheduled. The state and the defense attorney will appear before the judge in open court. They will call witnesses, they will present evidence, and they will both argue their side as to whether or not the defense has proven their burden or not. There is an appeal process that either side could take, but that's usually a last resort and can take a long time. So 99% of the time, the judge's ruling on that motion to suppress is final, and either the evidence will be suppressed and the case will likely be dismissed, or the case will move on.